I hand over to the next session, and my colleague Yukiko Nishikawa from Doshiha University, Japan, will be sharing the next session. Please, Yukiko.
Thank you very much. The final session for today is martial law, criminal justice, and emergency. Well, all the measures are same. Can I remind you to place your microphone on mute? And for participants and speaker alike, if you would like to ask question, please type it into the chat function. You will find the chat button at the bottom of your screen. I will read the question out in order. We have very limited time today, so let me first briefly summarize 7 excellent papers. Well, in the program, there are 6 papers. We are supposed to have 6 papers, but we received 1 additional relevant paper. So I would like to include this 1 additional paper, and altogether 7 papers. This session is martial law, criminal justice, and emergency. And these issues are often closely discussed in emergency situation. And all countries, perhaps to a certain extent, struggle to find the right balance between the executive power strengths during the emergency period, and also people's right and liberty that may be restricted to a certain degree, and how we balance them as in concern. And the 7 papers we received in this session are all excellent, mostly from Vietnam, and 1 paper from Thailand. The first paper, Professor Pham's paper, discusses the compatibility of the Vietnamese law with the right not to be tortured in a state of emergency. The paper shows that as signatory of the Convention Against Torture, Vietnam included relevant provision for the right not to be tortured in various laws, which was quite amazing. And the second paper, Professor Nguyen's paper, explored the role of criminal law and its reality on the state of emergency. It discusses how Vietnam's criminal law can meet the requirement of the state of emergency. And the paper ultimately suggests the proposed content to supplement in the penal code. The third paper, Dr. Min's paper, discuss Vietnam's law on state emergency on defense, martial law, and curfew. The paper quite clearly elaborates these terms in Vietnamese term, and it also explores a historical trajectory on the relevant laws and policy. Fourth paper, Professor Lee's paper, discusses the relationship between the state and its people in paternalistic state, particularly China and Vietnam. It suggests regulation on state of emergency in paternalistic states in reference to the formula to restrict human rights in criminal justice. Next paper, Dr. Roxana Brato's paper. I've got this paper a few minutes ago, and I haven't gone through, but it talks about corruption in terms of COVID-19 in the UK. UK had quite a large number of people who suffered from COVID. So perhaps it includes important discussion. Perhaps Roxana can later explain a bit about the paper. And the next paper is Professor Ekapans from Thailand, shows the enforcement of law on state of emergency along with several special laws on and legal instruments in Thailand. It reviews the effect of Thailand's long-sustained emergency law and the authoritarian mentality on the people and the entire society under the decade-long military ruling government. I quite enjoy this paper. The last paper, which was added later on, Professor Gwen Van Vie's paper, explored the role of the army in an emergency situation in Vietnam. It identified several key roles undertaken by the army in response to COVID-19. Okay, so to those papers, I raised very brief questions to each. And okay, first paper, Professor Pham Thanh Son's paper on the right not to be tortured in state of emergency under international human rights law and Vietnam law. The paper discusses how Vietnamese law included right not to be tortured in various ways. So I am interested in how these laws are enforced. Is there a mechanism to enforce those laws that include right not to be tortured? So I ask the author, is there any relevant law or institution to enforce the prevention of torture in emergency situations? So let me give microphone to Dr. Pham.
Your question. I realize that Vietnam's legal document have a more specific provision on fighting torture even in state of emergency, especially after Vietnam ratified the Convention Against Torture in 2014. The mechanism against torture in state of emergency is manifest in all three legislative, executive, and judicial activities. I think against torture, punishment, or cruel or humiliating treatment of human being is a basic principle that is thoroughly grasped in the law-making process. In principle of respect and assurance of human rights, action against torture, punishment, or cruel, inhumane, and humiliating treatment of human being is a thoroughly implemented in the provision of enforcement activities of state agency, especially SSC directly relates to law protection activities such as police, receipt, and cost in on circumstance, including in a public emergency. During the investigation process, investigating bodies must strictly abide by principle of respect and assurance of human rights. Action against torture, punishment, or cruel, inhuman, and humiliating treatment of people to ensure the right people's right crime, not to overlook crime, and not to wrongly exclude people. Thank you.
Okay, thank you very much. Okay, the paper completing the criminal justice and law on state of emergency. My question is, what actually hindered including those relevant clauses of state of emergency in Vietnam's criminal law? I would like to know why it has been absent for quite some time in Vietnamese criminal law.
Okay. Good morning. I'm Lan Chi. My colleague, Professor Chi, could not be here with us this morning. He's sorry for his absence and he asked me to give his answer prepared earlier. In his view, there are three things hindered. The one, Vietnam has not declared the state of emergency recently, especially since đổi mới in The practical requirement on response to incidents relating to the state of emergencies has not been urgent by the time of the COVID-19 pandemic. The second, the legal literature in the area of criminal justice in Vietnam on the state of emergencies and how the criminal law and criminal procedure law respond to the state of emergency is still limited. So far, there is no research has been made public. The third, the legislative space for the state of emergencies in Vietnam are still low at initial levels. We have only one definition in the constitutions. The Ordinance on State of Emergencies was promulgated by the Standing Committee of the National Assembly in 2000. The government decree in 2002 detailing the implementations of the Ordinance. The law on prevention and control of infectious disease in 2007. The law on national defense in 2018. However, the ground for dealing with matter in state of emergencies has not been fully stipulated. The legal framework of criminal justice is still inadequate. Thanks for listening.
Okay, thank you very much. You are Miss. You answer, Miss. If you don't mind, introduce yourself briefly.
I'm Nancy. I'm from the Department of Criminal Justice, University School of Law. I'm colleague of Professor Viên Học Trí.
Oh, okay, thank you very much. I appreciate. Okay, Dr. Min's paper on Vietnamese law on state emergency on defense, martial law, and curfew. My question is, well, this paper is elaborated well conceptually, but I'm wondering, what are the imminent issues for Vietnam surrounding this emergency on defense and martial law and curfew? I would like to ask the author, what are the contemporary challenges surrounding Vietnam with regard to law on defense, emergency state, martial law, and curfew? What are the current concerns? Let me ask Dr. Min.
Thank you, Chairman, and all of you. Thank you for Chairman question. Regarding the question, I would like to answer following. Regarding the contemporary challenges surrounding Vietnam in terms of national defense, emergency, material now, and curfew economic, such appear peaceful evolution, national disaster caused by climate change effect. In my opinion, they are risk to Vietnam. I thank you for the question and listening. That's all.
Okay, thank you very much. We may have other questions from the floor, but let me then move to next paper, Dr. Lee's paper on state of emergency, paternalistic state and criminal justice. The paper focuses on China and Vietnam as cases, but I would like to know what differences can author identify between China and Vietnam when creating regulation on state of emergencies. Both countries are paternalistic, but there may be some differences. So I would like to know the differences between China and Vietnam.
Okay, good morning again, colleagues and friends. In response to the first questions of Madam Chairwoman, what are the differences between China and Vietnam when creating regulations on state of emergencies? I think that is very interesting questions, but not easy to answer. Both countries are paternalistic states, and the regulations on state of emergency now are still insufficient. So the differences perhaps lie in the following point, and such differences may be attributable to contextual factors. The first, China is the most populous country, so the demand for control may be much higher than Vietnam with smaller population. So from the legal perspective, China's state need to have more power to handle the state of emergency in a sooner and more proactive manner. If not, the situation may become more turbulent and get more serious consequences. The second, China legislators need to consider the relationship between the levels the place occurs the state of emergencies and the competent agencies to respond to. China is an immense country, much larger than Vietnam, so identifying the competent agencies to timely respond to is very crucial. But the central authority has a tendency to keep the situation under the control, especially in the state of emergencies. The third, throughout the history, the need for dictatorship and application of deterrent measures, compulsory measures of Vietnam rulers were not as strong as China's. In China, it takes roots from universalism and sinocentrism of the Chinese. That is the differences in the political culture in the two countries, and I think such differences can be reflected in the regulation or state of emergency of the two countries. Thank you.
Okay, thank you very much. The Ekta-san's paper, I quite enjoy it. It's about the dynamic of enforcing the law on state of emergency in Thailand, which examined the enforcement of law on state of emergency together with other special law and legal instruments in Thailand. But I would like to know first the procedure to issue an emergency decree in Thailand. Can the Prime Minister decide the issuance and duration of emergency decree on his own discretion, on her own discretion? And also, I would like to hear the author's opinion about what measures are necessary to possibly limit the duration of the emergency decree in Thailand.
Good morning, Madam Yukiko. Thank you very much. The thing is, like, to respond to your question, that yes, of course, like there are certain limitations to the law. But the emergency decree is actually allows the Prime Minister to enforce this law by the by the approval, by the resolution from the cabinet. But they also allows that this resolution can be made without face-to-face meeting, which means that the Prime Minister can exercise this law anytime, and then ask for the face-to-face meeting to approve again later on. So then it is a kind of a very, very convenient tools for the government to do things. So that's why I mentioned very often in the paper that it's a chronic emergency. It means that we are in the situation of emergency all the time. You know, like if you cannot imagine of what the situation is, you imagine that we have the ambulance running and making the silence at all time, because we are all at the state of emergency. So that's why, like, various government, not just only this government, has been using this law as a tool to, minimize, like, they always justify that it is minimizing the chance of the violence and everything, but it gets worse with the military rule government, because of course it's very easy to use. Of course there are certain limitations. For example, like this decree can be enforced once 3 months each. But of course, like the situation in deep south of Thailand, it has been renewed for already like, I mean, it's like 10 years or even more. So the 3-month period of this of the enforcement doesn't mean anything, because they prefer to reinforce it over and over. Renewal, it's like every 3 months over like 13 years. So then that's how the situation here happening. The second is like when the military, you know, like frankly speaking, right now when I'm making this presentation, the secret agent just give me a call because like there are some protesting of some students, you know, against like the enforced disappearance, you know, and then right now they just claiming that it is also a violation of emergency decree, you know. Even this, the current emergency decree aims on controlling human being as a carrier of the COVID-19, but they are just like, most of the cases have been arrested have nothing to do with the COVID-19. It has been doing with all the political views and political actions. So this is like the chronic of the using emergency decree. So then it also balanced about like the rule by law and the rule of law, because they have, you know, they have certain, they make certain law and they are trying to exercise that law and then trying to make that this law is justified. Of course, it's justified because it's it's the law, but it doesn't contain any the moral of actually of the rule of law at all, because then they can enforce everything. The law right now that being initiated in 2005 is very similar to 1950 something law, and it's so close to the martial law already. It's already so close, you know, like and the martial law that has been using in Thailand is 110 years old law. So, you know, like if you go deep inside that law, you see like they can burn your house, they can, you know, do whatever they want, you know, like in your life. It's just like it's really ridiculous law anyway. So but the way that the people, I mean the government, many governments, even the elected government prefers to use this law very often, because it is the way that they can exercise, you know, like the overwhelmed authority, overwhelmed power, you know, and the people allows them to do so. This is even more ridiculous, because like, okay, yes, let it be, you know. Right now is the 3rd time renewal of the emergency decree to fight with COVID-19, and nobody says anything. You know, like the disease is almost like at a very slow pace of growing, like less than double digit for quite some weeks, but we are still having the emergency decree. That's why, you know, like imagine that we have the ambulance running around our house all the time, because we are always emergency, you know. And then apart from this, okay, this is like the fight, because like apart from this emergency law that government really prefer to use, we always have a lot of any other laws. Before we have the constitution, like Article 44 of the interim constitution, that allows prime minister to do whatever they want. Even the power of the executive power of the prime minister is overthrown. The court of justice, overthrown the parliament, the legitimacy of parliament, or things like that. So then Thai people love to, the Thai authority love this kind of law. And then there are any other laws, for example, like the Computer Act, Lese Majesty law, like 112, you know, if you say some very nice thing about like the king and all this, so then, you know, like they really like to use such law as well. And then, of course, like when the king is kind enough not to use 112, so then you use 116, which is actually the enemy of the state. you know, and then otherwise they have like the static lawsuit against the public participation. So they sue whatever, you know, that you just walk on the street and it's just like, okay, yeah, there are many other the instruments, the legal instruments that the Thai authoritarian government has been using. So then that's just how that's how things are going on here, and then it has been going on for a long time. So that's why I try to address in this paper that okay, enjoy it. You know, we live with it, and we're gonna live it for a long time. Okay, thank you.
Thank you very much, Ajahn Ekapan. You've got many questions. I come back to you later.
Right.
Okay. Another paper which is not on the program, but we received it later, and it's relevant, so we include it. It is a paper written by Gwen Van Vie, titled "The Role of Army in a State of Emergency," and the paper identified the key roles that Army takes during the emergency situation in Vietnam, with highlighting the situation of COVID-19. So I would like to ask Dr. Gwen if there was any civil military cooperation during the COVID-19, because your paper identified the Army's role, and I'm interested in whether there was any civil military cooperation.
Yes, first, dear participants, first of all, I would like to say thank to my chairwoman, Nishikawa, for the last question. I would like to say, first of all, I would like to give you there are some guys writing on the people Army Vietnam on the living in military barracks because of COVID-19. I love all of you, those Vietnamese people. I would like to thank each and every person for taking care of us, the soldier, the medical team, the driver, on the informed newspaper on today, 8 April 1990. Is writing of Professor Pichidu, a police and English nationality. And you are the guest note of Missy Mai, who was returned from Korea when isolated in military barracks, writing on People Army newspaper on the 1st of April 2020. 40 days in the military barracks was very warm and meaningful to the people and soldier. Officer and soldier of the units care and courage took care of each meal and sleep for the people makes everyone feel touched. The giving of the beds, carrying the consideration, the care of the soldier make us feel like we live in our house. There are some guest on the newspaper in Vietnam that shows us the very important role of the People Army of Vietnam in the 19 COVID. In the past time before the outbreak of the COVID-19 pandemic in the world, under the direction of the Central Military Commission, the Ministry of the Defense, the General Staff Department, the General Department of Politics, the English have organized over 9,000 tons of powder gas and soda no gun, shoulder, and shall defend militia, overcome difficulty, hardships, and readiness to stand around the clock at 1,645 teams, lecturing along the northern, western, and southwest border lines, forming a steam shield to spread the disease from outside into land. Actively consolidate epidemics via the barrack to organize 159 isolation places for nearly 70,000 people from foreign epidemic region to return home with the spirit of the dedicated, thoughtful service contributing to the tightening the feeling of the army. People leaving a deep expression on the country, the army, and Vietnamese people in the eye of the international friends. The victory.
Okay. Maybe you need to stop here. 3 minutes is over. Yes, somehow I could understand what you tried to say. Thank you. We come back to you. Maybe there are some questions to you too.
Okay,
actually, there are quite a number of questions I received, but Dr. Ekapan, can emergency law enforcement in Thailand during COVID-19 be justified?
Mm-hmm. Yeah, I see the questions in the box. And then, yes, it is justified because like this decree has been issued since 2005 and allows any authority, any government to enforce it with the certain conditions, you know. The condition is about like that the situation is really needed, something that threat to the national security, threat to life and the condition of living of people. So then all the governments can use that. So then it is justified in a certain sense that, of course, we might at least sometime having certain kind of emergency, you know. And even me myself, I was encouraged that this government should enforce this decree in the very beginning of the pandemic. But I expected that it will be enforced for maybe 15 days, not 3 months or 4 months already. So then, we need emergency, but we have certain emergency situation, but we don't have like this kind of long emergency. So then it was justified and it could be used in certain level. And another questions about like the emergency was issued in 2005 to replace the Emergency Act of 1952. The thing is like 1952 Act was very close to the martial law. And the martial law is really, really like, Thailand Martial Law Act is 110 years old, even a little bit longer. And yeah, somehow like that, 108 years old. Imagine that, you know, like you can even make people like caning people or things like that, you know, punish the people on the street or whatever. You know, it's 100 years old law. So 1952 law is very similar, you know, and then you can see that with the consequences of that law, that there were 6,000 people have been, arrested, or even the extrajudicial killing, during the issue, the enforcing of 1952 emergency law. So then, you know, it's better, but it's not the best, you know. And then the thing is like, and the next question, in the case of the conflict between emergency decree, the National Security Act of 2008 and the martial law of 19 something, you know, like it's not preferable because like yeah, like, well, which one do I prefer? It's not preferable at all because in the COVID-19 situation, let's say that this is the first time that this kind of law is enforced with a medical issue. The other times they are related to the political conflict or, you know, like using the power over another opponent groups and all this. So then it's not preferable because the healthcare and the infectious disease law in Thailand is already sufficient enough to exercise the control. You know, like just like a very recent example, the governor of the Kampotong province, where Mahidol University is located, exercised the public health law all the times. You know, like making orders referring to public health law. It was working, and even the very first days of enforcing the emergency law, he didn't dare to use the emergency decree. You know, I mean, his authority under the emergency decree, he was still using his authority under the healthcare law. And then, you know, like after he started to using it, he gets addicted to it. You know, like it's so convenient for him. He's safe. And then, you know, many other orders that come out from him later on, like in the past 3 months, has been done under the emergency law because he's protected, well protected under that law. And then, of course, that's why I don't prefer any of this law at all, because there are many other mechanisms and instruments that they can use. So does the emergency decree 2005 has a regulation on limitation of the government power or not? Yes, that's the maximum of enforcing it is 3 months, but with the capability of renewal. So that's why in the deep south of Thailand, they have been renew this law every 3 months for 14 years already. So you see, like it is, of course, there are certain limitations, but that limitation never limits if they really prefer to do so. So, and then why a little bit, it's not in this question, but I have to say why, because this emergency decree allows the government authorities to carefree of being sued by any parties at all. So it means that they can do whatever they want without being brought to court in the future. You know, so that's why they love to use this. I mean, imagine myself if I can do some authority under this law, I would be very happy because nobody can. I don't care about the complaint. I don't care whether I do anything to anybody, and then I'm carefree. Nobody bring me to court, and I will not be imprisoned for that. So then that's why they are addicted to using this law. So then that's all the questions. Thank you.
Thank you very much. We've got also questions to other speakers. Let me move to Dr. Leilan Chi about China's law. There's no particular and comprehensive law on state of emergency in China, but the state of emergency provision have been incorporated into the constitution and over various laws. The Chinese 2007 law is law on breaking incidents response. The first question, what is the difference, or is there any difference between state of emergency and martial law? Before the year of 2003, the term in the 1982 Constitution of China is martial law. It is modified to state of emergency in the amendment of 2004. And the second question, could we also apply criminal justice principle in state of martial law? Dr. Lanchi?
Yes, thank you. It's a very interesting but very long questions. Firstly, I'm agree with the with the term that the name in English, emergency response law, is not equivalent to the name in China, to 事件应对法, maybe translated into English as Breaking Incident Response Act. However, the key words, the natures of state emergencies, is mentioned in the Article 3 of the Act of China. For the purpose of this law, emergency include natural disaster, climate incidents, public health and accident, and public security incident. I think that it is similar to what we say the state emergencies. So the next questions. I think that there are some distinct points between the state of emergency and the state under martial law. The state under martial law exactly under the control of the army instead of the civil authorities. The state under martial law usually is stemming from the foreign invaders, war or civil conflict, and the army is empowered exclusive authority in a long-lasting period. And the characteristic of martial law distinct from what happened in the state of emergencies. Under martial law, the army is entitled to impose harsh measures, including arrest, custody, ban from moving of their residence, etc. Such restrictions are similar to deterrent measures in criminal justice system and need to be well defined, not only for the army to take initiative in preventing and recruiting the wrongdoer citizens, but also for the innocent are not unjustly punished. Okay. Maybe is there any questions?
Okay. Thank you very much. Let me then move to another question to Dr. Pham Thanh Song. Is there ordinance on state of emergency issued in 2000 consistent with Vietnam's current law on anti-torture?
Okay, thanks for questions. I realize that in 2000, it's still quite a long time, and of course, compared to other government issue recently, their point is that need updating. However, as a whole, the provision of the ordinance on special measure apply in emergency in event of major disaster, dangerous epidemics, a state of national security, emergency, and safety and social order is in appropriate. The problem that needs to be corrected here is to change the mechanism to cope up with emergency so the current context, the clearest evidence is COVID disease now. Thank you.
Okay, thank you very much.
May
Ajahn Ekaban,
I? Yeah.
another question. Is this correct? The current emergency decree related to COVID-19 has only one period, correct?
Yes.
Should end by 30th April and extended to 31st of May, 1 month?
And then it's extended to the 31st of June. and,
31st of June, okay.
and then they're going to extend it. And again, it seems like they are trying to test the water right now.
Okay.
And then that's and then that's why they're trying to test the water that whether the public will allow them to extend it another time. And that's the reason why I get a phone call from this the agent right now that they were asking like, are there any of our students going to the street protest today? Both issues like the enforced disappearance of the Thai activists in Cambodia, and then about like to make the government stop enforcing the emergency decree.
So
So
there's
I just
any legal measures to limit the emergency decree, the period.
So that's why I tell you, it's just like having the ambulance running around your house all the time, and then we never know already what is really emergency and what is not emergency, because we have emergency all the time.
Is there any ever trial to set maximum period?
The maximum period is 3 months.
3 months.
But of course, as I tell you, this 3 months has been already extended for 14 years, 13 years in the Deep South. So then anything is possible in this country, sorry. And sometimes it's very difficult to explain why, because it is not logical way of thinking at all. So they just love to use it. And of course, like this kind of law, people, the authorities get addicted to it. So, but the thing is, like in the paper, in the additional thing, without any other questions, but in the additional thing, in the paper, I was trying to address why. Of course, I'm not the lawyer myself, but I understand that why Thai. I wanted to understand why Thai people don't just come out and say that this is too much of emergency already. There are just only a couple of kids today. Right now, they are being arrested. Just coming out and making the protest that the government should not prolong or renew this emergency any longer. But most of the Thai people are really feeling comfortable, being protected under this law. I don't understand that. But the thing is, like, one thing that I just came out with is that because we are in the authoritarian society, as long as that the authority exercise the power, and we are just very, very good, kids, very disciplined kids. Whatever the parents telling us to do, okay, that's fine, as long as we are protected, as long as we are not arrested, everything is fine. So then this is the thing, So that's why every time that the government is trying to justify, okay, right now, this time trying to justify by making, less possible of the COVID-19 carriers and all this kind of thing, as a matter of fact, I believe that the number of infected people in Thailand is hundreds or even 1,000 times more than what they have announced. So then what the government is doing the best under the utilizing of the emergency law is controlling the information. The graph of the infected patients in Thailand is not normal, you can see. And Thailand is not a special country. It's even worse than any other countries. But the graph of the infected patients comparing to Japan, Korea, most more developed country, more developed healthcare system than Thailand is different. So then logically, we have to raise the question that maybe the number of infected patients in Thailand is very good, not because less infected patients really, but it is because they are very good in controlling the information by using the emergency law.
Okay.
So
Thank you very much. Perhaps we close this session here, and I would like to thank all authors of this panel and participants who gave us very rich and good questions. Thank you very much. And Dr. Roxana could not connect today, but her PowerPoint will be uploaded later, so everyone can access and read it. Thank you very much for all the participants and the speakers. Thank you very much.
Thank you.
Thank
Have
you.
a good day. COVID-free.
Thank you. So now I think we are reaching the end of our first day. I think you'll agree with me that today has been a really very interesting and quite exciting day with so many different voices and so much different information. So it falls for me now to say thank you. Thank you to the chairs, Sripafra, Professor and Yukiko-san. Thank you for all of your very hard work and preparing such excellent questions and guiding the discussion. Thank you also to all of the panelists who have all written very interesting papers, but in addition have prepared concise and very thought-provoking responses to the questions. I note that some of you have prepared written answers to the questions, and so if you are happy for us to compile these and share them, would you send them to Catherine and we will put them up against the questions. And thank you also to all of the participants who have asked a range of very interesting questions as well. So now, can I please invite you to come tomorrow? So day 2 will start at exactly the same time and will also be a 3-hour session with 3 different panels during the 3 hours. If you would like to check the conference website, we will be updating it with the new papers, the new PowerPoint slides, and that will give you a description of the conference program for tomorrow. Can I just note also that tomorrow in the program we have specified a period for general discussion at the end of the sessions. And so we are saving all of the questions which are in the group chat. And we're also saving, I note that there are also responses to questions in that chat. So we're saving those so that those will be available tomorrow. And if you have a question that hasn't been answered and you'd like to remind us, then please do that too. I didn't mention at the very beginning, but I would like to say now that you all know that the reason why an online conference like this works successfully is because there is somebody who is enthusiastic and competent and has devoted many, many hours to making it work. And that's Catherine Taylor. And she has been working day and night over the last several weeks to make this work. So I'd just like to acknowledge her contributions. And looking forward to seeing you tomorrow. Thank you so much. And so we'll say goodbye now.